Good afternoon, good evening, everyone. I am Kevin Terraciano, the chair of the UCLA Meyer and Minna Stern Department of History, and I welcome you to our White History Matters program, which is sponsored by the History Department. We've had more than 20 of these programs since 2011, since David Myers, when he was chair, created this program. And we emphasize the importance of knowing the past in order to understand the present, and the idea that history can help us make informed choices in the future. We all feel that history does matter. Now, past topics, we've had more than 20. Some of them are really relevant to today's discussion, such as women's rights as human rights. One was on trying to make sense of the 2016 election. So trying to make sense of that. And how to address this very compelling and important issue, reproductive rights and justice. We have three experts on hand to address this topic. First, Cary Franklin, McDonald Wright Chair and Professor of Law, Faculty Director of the UCLA Center on Reproductive Health, Law, and Policy, and Faculty Director of the Williams Institute. Elizabeth O'Brien, Assistant Professor of the UCLA Meyer and Minna Stern Department of History. And Alexandra Minna Stern, Professor of the UCLA Department of English and Director of the Sterilization and Social Justice Lab. We'll go for about 60 minutes, maybe a little bit more. And I want to thank in advance Ann Majors and Serena Silk from the History Department to organize this event, and Peter Evans from Development. Dobbs versus Jackson Women's Health Organization was a landmark decision addressing whether the Constitution protects the right to an abortion. I'm going to hand this over to Professor Franklin and speak directly to this issue.
Thank you. So I just wanted to lay a foundation by talking a bit about Dobbs and what has happened since. History, or maybe I should put that in quotes, history just became much more boring. As a legal historian, I am not cheering, and I'll explain why. Okay, so in 2022, the court held in Dobbs that there was no constitutionally protected right to abortion. Historically, here's how the law worked. After the Civil War, the 14th Amendment is passed. The 14th Amendment protects liberty and it protects equality, but it doesn't say what those concepts mean. So the Constitution protects your right to liberty and your right to equality, and over time, the court translates that into workable doctrine and law on the ground. So how the court's done that is to say, we're guided by historical principles. We see, for instance, that there has been a right to marry protected throughout history, but we also have evolving understandings that interracial marriage was actually part of that. People love it would be deprivation of equality for same-sex. There's an evolving understanding of the concepts of liberty and equality guided by historical principles. This was the way the court reasoned in Brown versus Board of Education. This is the way the court reasoned in. Then in 2022, the court in Dobbs introduced a new test. And what the court said is, actually, we've been doing it wrong. The correct term of the Constitution is by looking to history and tradition. So now we have a history and tradition test. And what this test says is you have to define the right at a very high level of specificity. You have to ask, was there a right to get an abortion? And then you have to look whether that was deeply rooted in history hundreds of years ago, and particularly in 1868 when they enacted the 14th Amendment protecting liberty and equality. Did they view abortion as a deeply rooted right in that period? So that is the test in Dobbs. And Justice Alito, writing for the majority, says, no, it's ridiculous to say that there was a deeply rooted right to abortion in that period. And here's what he does historically. He says, increasingly in the second half of the 19th century, so right around when the 14th Amendment is enacted, new bans on abortion are coming in. These abortion bans, some of them last all the way through Roe. And if you go back really all the way to the days when they were burning women at the stake as witches, you'll see that we've banned abortion and barred abortion all throughout history. So to claim that there was some deeply rooted right to abortion throughout American history is ridiculous. This is an easy case. No right to abortion. Roe is overturned. Okay, so I'm just going to go through a couple of problems that every major historical organization in the United States has come out and said that history is incorrect. Almost all historians concur with that view, that this history is problematic. I'll just talk for 1 minute about why. Okay, so actually at common law, it was viewed that the state was not allowed to interfere with people's pregnancies prior to quickening. And quickening was about 16 to 20 weeks. That's the point at which you feel fetal movement. And at that point, there is some tradition of laws limiting, restricting access to abortion procedures. But before that, at common law, there was not. And throughout history, there were not viewed as the state's prerogative to restrict people's choices and rights and activities prior to quickening. That began to change right around the time of the 14th Amendment. There was a campaign to pass more different new abortion restrictions. The leader of that campaign was named Horatio Storer. He was concerned that women were having sex without punishment, pregnancy. He was concerned about the morals of Americans, women, that they were becoming too loose, and he wanted to stop that behavior. He was also concerned, because most people in that era who got abortions were white Protestant women, that Catholics who were not getting abortions at the same rates would overrun America. And that he viewed that as a really frightening prospect, right? So to preserve the racial composition of the country, to make sure women lived up to their marital and maternal duties, he launched a campaign to get more restrictions on abortion. And this succeeded. He got some allies in legislatures, and states started to press bans. I just want to also note that this is a period in which women couldn't vote. Women did not get the vote until 1920, so all of these laws were passed with it at a time when most of the population is disenfranchised and didn't get any say in the passage of these restrictions. So it is problematic constitutionally to rely on that history, which raises a lot of equality concerns under the Constitution today. It's problematic because it's bad history and doesn't accurately report what the customs and traditions were in the past. And then there are bigger questions about whether we really should be looking back to the 18th and 19th century for what the meaning of the Constitution is. That's a whole another question. But I guess I just want to close by saying two ramifications today that we're dealing with as a result of this change in legal doctrine. The first is a new history and tradition test doesn't just affect abortion. It affects all of the kinds of rights that were viewed as evolving rights over time. Contraception is a big one. We will see increasing fights over contraception. Same-sex marriage, right? Ask yourself, in 1868, did Americans view it as a deeply rooted right for two people of the same sex to get married? They didn't. Even if you don't know that much history, they didn't. Right? And same-sex intimacy, right? We decriminalized same-sex intimacy about 20 years ago. Was that viewed as the same? Right? We're going to have now all of these questions about not just abortion, but a whole bunch of rights that were arguably not deeply rooted in either 1791 or 1868, depending on when the constitutional provision that's relevant was enacted. And the second thing I want to say is there has been a groundswell of opposition in this country to what the court did. Right? Americans are not going along with this. This is wildly unpopular. The vast majority of Americans believe that people should have a right to abortion, and we're seeing that play out electorally. One thing I like to remind people of, what the Supreme Court held is that the Constitution doesn't protect this right. That doesn't mean that we can't protect this right legislatively. 4 states since 2022, including California, have amended their constitutions to protect reproductive rights. There are 10 ballot measures currently this election cycle on state ballots, and people are voting on them. The outcome of the state of reproductive rights in this country, we'll say more about this as we go on, will hinge very, very dramatically on the results of this election. So we'll talk more about that, but I want to turn it over to Alex.
Great. Thank you so much. I want to actually just build on much of what you've laid out for us by bringing in the concept of reproductive justice and really thinking about what that concept is and how it underscores the right for a person to have a child, to not have a child, and to raise that child in a healthy environment. Those are the three pillars of reproductive justice. And all of those pillars, well, they've been stressed and strained for many years in the United States. We've obviously never achieved them, but they are under pretty much direct attack in a range of different ways across the country, in a patchwork pattern that we do see across the states. There's, as we know, there are differential situations from state to state. I just want to share that I'm drawing a lot of what I'm going to share with you about the history of reproductive injustice from the work that I do at the Sterilization and Social Justice Lab. This is a lab that I founded initially at the University of Michigan, and I moved to UCLA when I came here 2 years ago. It lives very happily, thank you very much, in the Institute for Society and Genetics, which has been a great partner in this work. So it has found a home there. And what we do in the lab is we have gathered data from 5 states of the 32 states that put eugenic sterilization laws on the books between 1907 and 1937. Those 5 states have more than 35,000 records, so they have more than half of the 60,000. They cover more than half of the 60,000 sterilizations that occurred under state laws, which basically targeted certain individuals for sterilization based on presumed unfitness. Those were categories that were racialized. They were connected to poor people, people with disabilities, women of color, marginalized people, and immigrants. And at the lab, we use qualitative and quantitative methods. So we do narrative, we do numbers, we do data crunching, we do historical context, and there, we have learned a great deal about these patterns over the course of the 20th century, most notably in California. And I could talk for night and day. You just poke me and I will start talking about eugenics in California and sterilization because I've studied it so extensively and we've learned so much. Our lab has been also not just a research hub. We have been involved in working with advocacy groups to promote reproductive justice and to think about history in its connection to reproductive justice work. Thus, when the Dobbs decision came down in the summer of 2022, we issued a statement. And the statement was really, not surprisingly, urging us to consider that this decision would usher in a new era of reproductive oppression in the United States. And an era of reproductive oppression that was not just tied to the denial of abortion rights, but that was connected to the 3 pillars of reproductive justice, the right actually to have a child as well. And our deep concern for this stemmed from understanding reproductive health choices and politics through this reproductive justice framework. And anyway, I won't read you the whole statement, which I copied and captured in case I wanted to share it, but let me just give you a little bit, more background on eugenic sterilization in the United States and how this is connected. So as I mentioned, in 1907, states started passing eugenic sterilization laws. The first state, interestingly enough, was Indiana. California followed 2 years later in 1909. And the last state to pass a law was Georgia in 1937. And again, over that course of time, over 60,000 people were forcibly sterilized, primarily in state institutions. These were like mental hospitals or homes for the feeble-minded. For those of you who have grown up in California, you've probably heard about places like Sonoma and Napa, Mendocino, Camarillo. These are the kinds of institutions where people who were deemed unfit were sterilized. And we know from many of you are probably familiar, I'm sure you're very familiar with the 1927 Buck versus Bell decision, when the U.S. Supreme Court upheld a state's rights to sterilize in the interest of public welfare. Basically saying, this famous line from Oliver Wendell Holmes Jr., 3 generations of imbeciles are enough to justify the cutting of the fallopian tubes. The state can intervene for the common good and the protection of the public health. So, we have traced this over time in North Carolina and California and other states. What we see is that when I first wrote about this history, I was kind of viewing it, this was when I published my book in the early 2000s, I was very naive. And I kind of thought this history had kind of ebbed and flowed and that things had really changed by the 1970s. In the 60s and 70s, there was another bout of forced sterilization that involved newly available Medicaid monies through the war on poverty, where there was a lot of residual racism and anti-poverty. And this is, for example, when Fannie Lou Hamer received her famous Mississippi appendectomy. And our lab is currently pushing our research up into the 60s and 70s. We found a new data source in the National Archives, and we have found over 200,000 poor women in county hospitals and facilities across the United States who were sterilized with federal dollars during that time. Just note, some of those women did want to be sterilized, and that was something that makes this kind of a nuanced discussion. In any case, but looking at it, what you see by the 1980s are some shifts where sterilization laws began to be checked and safeguards began to be put in place because of class action lawsuits, because of congressional hearings, because of cases you may have heard of like the Ralph sisters. But what happens, though, is, and we also have a new era by then of, Roe v. Wade. So 1973, one thinks this is an era where there's more reproductive rights and autonomy. However, it's a very, very checkered history. And so some of you may be surprised to know that between 2006 and 2010, over 250 women in California women's prisons were forcibly sterilized. This was discovered by a women's prison advocacy group that was always sending out questionnaires trying to get information, and they started getting information about unwanted hysterectomies, unwanted ablations, a range of different procedures. This then triggered more kind of news investigation, ultimately an audit by the state. And my lab contributed to the passage of a compensation bill for women who were forcibly sterilized in the prisons, and also the individuals, including many men, who were sterilized in the state institutions in the 20th century that I mentioned before. The reason I tell you all this is that, this country, and even the state of California, has a great propensity to fall into pockets and eras of reproductive oppression. And I've thought a lot about in my work, what are the ingredients that need to be in place for this type of oppression to happen? Well, typically there are vulnerable populations who are either hypervisible or invisible. They are often corralled up or targeted, classified, sorted in certain ways, end up in certain facilities, and in places that have very little oversight or there's a lack of regulatory control. So it is not then that surprising that in 2019, cases began to be reported of coerced hysterectomies in an ICE facility during the tail end of the Trump administration. And so I'll talk more about some of the connections between anti-immigration discourse and kind of reproductive oppression. But I just really want to underscore, as Cary was saying, that it's definitely important to talk about abortion rights. Abortion rights are interlinked with other types of reproductive and sexual rights, for that matter, which include contraception, the right to have a child, not to be sterilized against one's will or be kind of coerced into using long-acting reproductive control like LARC. Some of you may have heard of that. So it is a kind of wider panorama, and I think it's very important to be aware of that because sometimes the most vulnerable are on kind of the other side of the reproductive justice equation. So with that, I'll pass it to Elizabeth. And you have your own mic, so yeah.
Thank you so much. Thank you, Kevin Terraciano, Cary Franklin, and Dean Alexandra Minna Stern. I'm honored to be in conversation with you all about this important topic. Like many of us and many of us here, I'm deeply concerned with legal and social efforts to force people to carry pregnancies or to forcibly remove people's ability to carry those pregnancies, including pregnancies that are unwanted and or can maim or kill people. And I'm especially concerned with how these attacks on reproductive people's health, dignity, and right to bodily autonomy dovetails with other forms of violence in our world, especially when having to do with racism and misogyny. When the Supreme Court ruled on Dobbs versus Jackson, we knew that states with trigger laws would see increased and preventable death and suffering. And indeed, we had been seeing that borne out in the past couple of years, in addition to witnessing inspiring struggles to codify increased healthcare protection. So my perspective that I'll share with you is more of a comparative perspective. I'll discuss some details of two Supreme Court decisions in Mexico, which came down in 2021 and 2023 that had expanded access to abortion. And I want to focus in particular on the role of grassroots activism in Mexico, as well as a transnationally inspired reproductive justice vision that led to securing these wins. The most important thing to know about reproductive rights and reproductive justice movements in Latin America is that they have been strongly influenced by social movements that sought and seek accountability, restorative justice, and reconciliation from regimes that systematically targeted vulnerable groups by inflicting terror and repression onto them. The kind of terror and repression, I think not coincidentally, that former President Trump has been saying that he is in support of in recent weeks, and for longer than that. Inspired by those struggles, reproductive justice movements in Latin America have argued that the criminalization of abortion constitutes an act of violence against childbearing and potentially childbearing groups as a whole. So that it's not just a matter of individual rights, but that a lack of access to dignified healthcare is an act of violence against entire groups of people. And that any less than a holistic protection of access to contraception, to healthcare, to paid family leave, to childcare, and to adequate wages and nutrition is a form of state-sponsored violence. This came out in the language in the Supreme Court decision on abortion and the decriminalization of abortion in 2023 in Mexico, in which the judges specifically used phrases and language that I'll discuss, including that of reproductive freedom, and they spelled out the fact that reproductive freedom requires infrastructure of access to that freedom. Otherwise, it doesn't matter. It's just words and not infrastructure. And then if we have time, I want to talk a bit as well about pre-modern ideas regarding pregnancy and pregnancy loss and what they can tell us about the uses and misuses of history that Cary Franklin spelled out so beautifully in regard to the Dobbs decision, right? I think it's important to challenge the notion that the Catholic Church has some kind of immutable, preordained, unchanging, unshiftable belief in the importance of protecting unborn life and unstaged pregnancy. And so I mentioned this because sometimes a comparative approach can really show not only how history is being misused, but also how these comparisons, kind of dug into, not only tell us something extra about United States history and the assumptions that wrong assumptions that people were making in terms of pitting Protestant versus Catholic reproduction against each other in the 19th century. So ideas about Catholic positions on unborn life are oversimplified. Even when pre-modern theologians wanted to argue that the products of early pregnancies were animated or ensouled, Catholic doctrine prevented them from claiming that animation occurred at or near conception until the 19th century, because for one thing, this claim contradicted Aquinas' writings. So the most influential jurists of the 16th and 17th centuries, jurists and theologians, did not equate an animated fetus with a born child, nor did they equate abortion with homicide. For civil jurists, and very, very importantly for the general population in the pre-modern era, viability, the stage at which a fetus was thought capable of living outside of a woman's body, mattered much, much, much more than ensoulment or animation. And Cary already mentioned this. So before the 7th month of gestation, a fetus was not legally considered a human being because it could not live in the world as a human being, and it was not treated as such in Catholic doctrine, theology, law, or practice. Catholic theologians did not even seriously consider making the argument that products of conception were animated until at least the 1740s, and they did not insist on this argument until 1869, when Pius IX removed the distinction between animated and non-animated fetuses. So, as many historians have insisted, the contemporary notion of fetal personhood is a very, very, very recent invention, right? It's post-Rome. And the part of that we see, in Mexican history, for example, the Catholic countries did not have the Comstock Act, did not have the same prohibition on contraception, and did not have the same kind of movement that Horacio Storer led, in which a male medical profession became united against abortion So these things were very particular in ways that Dean Stern has mentioned to the United States, and as she explained, have a lot to do with the racial politics of the history of this country.
Thank you so much, Elizabeth. Let's talk about surveillance, criminalization, punishment, and the shifting landscape of abortion care. About 2/3 of abortions in the U.S. in 2023 were done with mifepristone or misoprostol, the two-pill combination found in anti-preg and similar products, which are generally extremely safe. Therefore, medication abortion is disrupting abortion bans. At the same time, modern surveillance technologies enable law enforcement investigations of abortion crimes, and some states have intensified surveillance of people seeking to terminate pregnancies in order to criminalize their actions. Examples include SB 8 in Texas, which authorizes private citizens to take civil action against women who end their pregnancies in other states, seemingly taking its cue from Texas and states like Florida and Georgia. Project 2025 calls for every abortion, miscarriage, stillbirth, and incidental pregnancy loss from medical treatments like chemo to be reported to the federal government. The plan even calls for increasing surveillance for women by rolling back privacy protections. What does history tell us about how to understand these worrying trends of heightened surveillance, investigations of pregnancy outcomes, and the desire to criminalize reproductive health decisions? Beginning with you, Cary.
I want to talk for a minute about the Comstock Act, which should be much more familiar to people than I think that it is. Although, stay tuned, we all may become very well acquainted with it. Because it has to do with this question of surveillance and control. So, as you may be aware, I think it was alluded to earlier, that there's been an enormous shift in the technologies of abortion over the recent decade or two. 2/3 of abortion in America, almost 2/3, is now done by medication abortion. That is a two-pill regime that people can take in their own homes. In some places in Northern Europe, it's like 90% of abortion is now medication abortion. This is a huge change. The number of surgical abortions has gone way down, particularly in heavily industrialized countries, and medication abortion has become very prominent. So you may have seen in the newspaper that since Dobbs, the number of abortions has gone up. Right? Since recriminalization and all the surveillance and all of the law enforcement, not only has that not reduced the number of abortions, the number of abortions has gone up, and that's in large part because medication abortion can now be sent through the mails. And it is a lot easier to obtain it if you don't need to get to a clinic and you don't need to go through all that rigmarole that makes it very difficult. So if you are an anti-abortion advocate, you are going to be quite concerned about medication abortion. And here is a strategy that anti-abortion forces have recently hit upon, and we'll see the fate of this new campaign, but let me just describe it. So anti-abortion advocates discovered on the books an 1873 law called the Comstock Act. Anthony Comstock was in charge of the U.S. mails. He was an anti-vice crusader, and his campaign was against illicit sex. He was absolutely obsessed with, especially women, how they were dressing, what they were doing, how they were behaving, the whole 9 yards, and he spent his life crusading against this. One of his most powerful legacies is this 1873 law called the Comstock Act that bars the use of the mails to send obscenity. Right? This was an anti-obscenity law that barred sending kind of pornography, dirty pictures, information about contraception, contraception itself, and it says anything used to procure an abortion. Okay. That is the text of the Comstock Law. It's an anti-obscenity law designed to stop women from having sex without consequences, seeing dirty pictures, getting any information about contraception or how bodies work, right? That's Anthony Comstock. That's that law. That law was not understood to apply to healthcare. Anthony Comstock himself says this does not apply to doctors dispensing medications and procedures to patients. This is bad, illicit people who have an illegal purpose in mind, who are sending this filth through the mail. That's the understanding of this anti-obscenity law in the 1870s and since. Now, there was prosecution under this law for obscenity. Margaret Sanger sent around information about birth control, and she had to flee to Europe because Comstock and his forces are pursuing her. They arrest her husband, because he's also involved with sending contraceptive information, and they go after Ulysses, they go after modernist literature, and this gets into the courts in the 20s and 30s, and the courts say it's unenforceable, right? They interpret it in such a way that it falls into legal world, we say desuetude. It falls into desuetude. It's not enforced anymore. The courts gave it an interpretation that means it's unenforceable. So it has lain for 100 years. But anti-abortion forces recently discovered it and are trying to interpret it as an abortion ban. They say, we didn't even need we don't even need to pass any laws. What we didn't realize, we've banned abortion in this country for over 150 years because you are not allowed, they say, to send anything that could be used to produce an abortion. That's not only abortion pills, that's forceps, that's sterile gauze pad, that's any equipment, any medical equipment travels in the mail. So they say abortion is already illegal, effectively illegal everywhere in the United States, and it has been for 150 years. So at a recent oral argument in a case involving mifepristone that the Supreme Court kind of punted on, we'll see it come back probably next year, Justice Alito and Justice Thomas expressed excitement and agreement with this reading of the Comstock Act. Not only that, it is part of Project 2025. Project 2025 explicitly states that we will interpret, the Trump administration will interpret the Comstock Act to ban the use of the mails to send anything that might be used for abortion. That includes abortion pills, which, by the way, are 2/3 of abortions in this country right now. I'll end by saying I have been extremely frustrated. I get a lot of journalists and a lot of fact checkers calling me. They're saying, President Trump is now saying he would veto an abortion ban. So so what's the big deal? Everyone's in agreement that abortion is going to be legal in this country. I am trying desperately to get across the point that he can say that because, one, Congress is very unlikely to pass an abortion ban that's wildly unpopular, and it's very unlikely to happen. But two, he can go ahead and ban a new law if Congress were to pass an abortion ban because he's already viewing the Comstock Act as an effective ban on abortion. So that's why he can say, sure, I'll veto an abortion ban because his administration has already embraced the idea that the Comstock Act, Congress doesn't need to act. We already have an abortion ban in this country. It is called the Comstock Act, and we plan to revive it. So this should be a bigger story than it is because I was just thinking last night, what would it look like if there is a Trump administration that interprets the Comstock ban as a ban on abortion and enforces that against the sending of pills or anything else in the mail that could be used to produce abortion? I find it hard to fathom what that world will look like, but it is a whole lot more frightening than the pretty frightening reality that we are currently living in.
Well, I have to take that in. Yeah, and I want to say a few things about Project 2025, but, we're currently living in an era where there's like biometric surveillance, there's app surveillance, there's, one is in the criminal legal system, there's surveillance. So there's a whole range of different surveillance and medical surveillance and so on. And we know cases in which pregnant women seeking abortions or not even seeking abortions, but, having, inadvertently used drugs in the context where they're pregnant being criminalized, even being imprisoned, and some even, suffering harm and or death. So that There are excellent scholars who've written on that. I want to take us back to the kind of mid-20th century to think about some of the ways in which surveillance was working during the eugenics era. And one of the ways it was definitely working was through the school system. So, if you were just looking at Los Angeles, who was being targeted for sterilization and for, reproductive irresponsibility? Well, it was for the most part, overwhelmingly, young, poor women, Latina girls. So our research found that Latinas were sterilized in the eugenics era at rates 59% higher than non-Latinas. So you can look at this as a concerted attempt to forestall the future. Now, luckily, California has had its revenge, and we're a primarily Latinx state and all of that. But nonetheless, that was, and how was that done? It was done through the school system, it was done through parole officers, it was done through the court system, and all of these elements which we know are part of kind of, let's say, the school to institutional pipeline, the school to prison pipeline, and so on. And there were other kinds of tools that were used, such as IQ tests. So, if a girl wasn't doing well in school, she would be pulled in by a juvenile parole officer, given an IQ test. If she scored lower than 80, she would be deemed feeble-minded, maybe sent to the Ventura School for Girls. We can just talk about Los Angeles. I mean, one of the most famous cases is a young girl named Andrea Garcia, who grew up in Boyle Heights and was going to high school there, and she was not attending school all of the time because she was one of 9 children and her mother was a widow. They were all trying to work. She had to go from kind of house to house and sometimes lived with her aunt. And lo and behold, in the sterilization record, what you see is like, who turned her in? Well, it was the attendance officer at the school, citing her for, basically tardiness and truancy and so on and so forth. Then she ends up in the Pacific Colony, which was based in Pomona. And eventually her mother fights the sterilization, and that's a whole other long story. So I just want to say there are kind of old-fashioned types of surveillance, which lay the groundwork for the kind of surveillance we see today. And also, it is not atypical for young people and youth to be surveilled and to be tracked. Another example I'd like to give is, really thinking about scary things and the possibility of, kind of rounding people up and putting them into the camps and so on. Another member of my research team and I have a paper coming out in the Journal of Family History, which looks at about 30 cases of Japanese Americans who were incarcerated at Manzanar and Hart Mountain and other facilities, who were sterilized by the state of California. And so they were, double kind of subjects of the state. They were under the control of the WRA, the War Relocation Authority, so they were deprived of their rights, and they became wards of the state of California, and they were shuttled back and forth. I mean, this is very eerie to think of. How were they moved? Like, there was a lot of conversation. Are we going to move them by train? Are we going to move them by car? How are we going to get this person from Manzanar to the Sonoma State Facility where they would be subjected to the operation? Now, this was a sliver of the 120,000 people that were incarcerated in the camps. Nevertheless, I really think it's an important part of the puzzle because it shows the role of certain types of actors, in particular social workers at the time. They played an inordinate role in basically identifying, moving, and facilitating. So I think it's really important to be aware of who the actors might be, in these kinds of cases. And we can think of what happened in the ICE facility as well, and who allowed for that, and who were the physicians who were involved, and so on and so forth. So I guess I think in terms of, we can definitely go to high-tech surveillance right away. But from the historical record, there are many other layered examples of surveillance that basically involve, people of certain classes policing other people so that they can control them. And later I want to talk more about demographic anxieties and racism, another kind of cheery topic. So, but I'll...
Yeah, well, For a bit of a comparative perspective with Mexico, until recently, I think it's relevant to know that approximately 97% of women in the entire region of Latin America and the Caribbean, 30-some countries, live with very strict restrictions on access to the termination of pregnancy. And so, feminists in recent decades in Latin America and the Caribbean have come up with this concept of forced maternity to describe that condition. And so in some ways, we can, look to this kind of criminalization and surveillance that has been happening in other parts of the world as a potential future for the United States. And of course, this had, health implications. So if every year in Mexico, 1/3 of pregnancies end in abortion, for example, preventable pregnancy-related complications, including those stemming from illicit and unsafe abortion, is the fourth largest cause of death of Mexican women's death annually. And I think it's very, very notable that poor and indigenous women in Mexico are 9 times more likely to undergo a safe and potentially unsafe and potentially dangerous abortion procedure. And so basically what these statistics bring us to is this nexus of race, class, language, location, and access. Because what we've had historically in Mexico, I mentioned there was no Comstock Act, there wasn't as strict of a prevention on the access to contraception, and that persisted, right? So even before the legalization of access to pregnancy termination in Mexico, anybody could go to the pharmacy and they could access, the medications that could be used to terminate pregnancies. But then what would happen? If they didn't have private health insurance and couldn't access a private doctor to, have the appropriate care, if they needed a DNC, if they needed follow-ups, if, anything went wrong with that medication abortion, then they would end up in a public clinic, which, is wonderful that everybody is guaranteed access to free healthcare throughout all of Mexico. But the women who would end up in public clinics with pregnancy complications were those who could not afford access to private practitioners, right? And so what ended up happening in just the past 25 years in Mexico are over 20,000 criminal investigations, many of them against Poor and indigenous language speaking women in Mexico. Many of them claim that they simply had miscarriages. And that they have no culpability in their unsuccessful pregnancy termination of a pregnancy that did not lead to a live birth. And for some kind of comparative cases, there's a woman named Imelda in El Salvador who is one of many dozens of women who was imprisoned for over a decade because she was accused of attempting to terminate her pregnancy. But one of the really striking things about Imelda's case is that her child was born alive. Nobody terminated the pregnancy. And so, there was no need for her incarceration for these many long years in which her child, didn't have a mother, except for a regime of surveillance, punishment, and forced maternity, right? And this kind of history of being able to access pregnancy termination in Mexico, if you had the means to do so without being surveilled and criminalized for it, is transnational as well, because we know that before Roe, men and women went, for example, to Mexico and other countries. And then I'll just add a couple of really quick kind of comparative comments on the pre-modern era, right? Because a lot of the surveillance, and punishment and criminalization, and, oppression and repression that we're talking about is done kind of, through the infrastructure of a modern state. And so we, kind of take for granted the idea that there's going to be modern authorities. But it's interesting to look at pre-modern history when that did not exist. How was pregnancy loss understood, right? So I'm talking now, I'm drawing from the work of other scholars, especially John Christopher's book has been really influential to my thinking on this lately. And first of all, one of the things that we know about pre-modern pregnancy termination is that abortion as a concept had many meanings. It could be the result of an accident, an unintended consequence, the result of a therapeutic intervention. Pregnancy could be misdiagnosed. It could be genuinely misdiagnosed, it could be incidentally misdiagnosed, or it could be intentionally misdiagnosed. Abortion also, as a concept, could refer to just the loss of pregnancy, a miscarriage, right? And so, this is really a relevant concept to today's time as well, because pregnancy is in so many different ways. It's not possible to just separate, abortion from miscarriage. And then, another, notable aspect, right, of the pre-modern era is that abortion was often seen as a man's crime. It was often seen as something that a man was responsible for and that a man would be punished for. It was a man's fault for impregnating a woman. It was often seen as a man's fault for proffering drugs that ended the pregnancy, or, a lot of the cases that we have, the legal cases that have to do with the loss of a pregnancy, were actually aimed at men who had done something antisocial or violent to harm a pregnant woman, thus resulting in the loss of her pregnancy. So those cases in the pre-modern era were not about the loss of the life. They were about larger circumstances that brought an unhappy end to a pregnancy. And so I think we see over the course of modernization this kind of increasing tendency to see abortion as something that is gendered in a way that blames women, that makes it women's responsibility. And this is ironic, right? Because not just women get pregnant. It's not people who don't identify as women also have uteruses and also get pregnant. It increasingly kind of became gendered and criminalized and surveilled, especially, with increasing access to birthing people's bodies, because of course, before the 1800s, physicians would not really be attending births. It would have been midwives, and women who were attending births. And, even on the case that, someone would have been reported, for example, to an inquisitorial or religious authority, what we see in those cases historically in the pre-modern era is that also had to do with class and reputation status. So those that were liked and deemed honorable, and who had abortions for reasons that did not disturb the moral sensibilities of their community, were almost always pardoned, absolved. It was not a problem. Right? And that's a broad generalization, but it's one that I think, helps make a kind of important comparison to this era of intense surveillance and criminalization we're in now.
Thank you, Elizabeth. Supreme Court Justice Alito wrote that the goal of preventing abortion does not constitute invidiously discriminatory animus against women in particular. And yet recent data has shown that abortion bans have led to an increase in preventable maternal mortality rates. Recent analysis claims that the rate of maternal deaths in Texas, for example, increased 56% from 2019 to 2022, compared with just 11% nationwide during the same time period. Two prominent examples of this trend come from Georgia, where ProPublica characterized two women's deaths as preventable and determined that they were caused by the state's abortion ban. Many predicted these outcomes. In their joint dissent to Dobbs, Justices Stephen Breyer, Elena Kagan, and Sonia Sotomayor decried that a state could, quote, force a woman to give birth, prohibiting even the earliest abortions. Some women, especially women of means, will find ways around the state's assertion of power. Others, those without money or childcare or the ability to take time off from work, will not be so fortunate. Maybe they will try an unsafe method of abortion and come to physical harm or even die, end quote. CDC data also shows that infant mortality rate has spiked in states with abortion bans. A new paper in the Journal of the American Medical Association of Pediatrics found that infant mortality was higher than usual in the U.S. after the Dobbs decision and never dropped to rates that were lower than expected. So, my question is, what does history tell us about the ways in which reproductive oppression harms people on the basis of sex, gender, and ability to become pregnant, and their children as well? I don't know. Maybe Alex, would you like to go with that one?
Sure. I mean, basically, you've laid out a lot of the foundational, framework for understanding how reproductive oppression can work for women and pregnant people. And, we have seen what's unfolded just in the past 2 years since the Dobbs decision. Again, it's unfolded differentially across different states, and we rely on news organizations like ProPublica and Stat News and others to capture these cases and show, how the harms are playing out. The prospect of, we're just like literally countdown a few days away from the election, the prospect of, a return of a Trump presidency or the enactment of a Project 2025 would obviously take this to the next level. And I do want to just take a minute to really underscore that we should make no mistake that this reproductive oppression is attached to white supremacy and racism. And I'm going to read you 3 quotes that Trump said to news media in the past 10 days. Okay, so this is just the past 10 days. And I'm sorry, you can cover your ears if you've already heard them. For 4 straight years, Kamala has imported an army of illegal alien gang members and migrant criminals from prisons and jails and insane asylums and the worst mental institutions anywhere in the world. So
It should be Kamala.
Yeah, well, I guess I was giving, I had to at least modify that, but yes, he would say it that way. So here we've got the 4 straight years, and look at the words, the key words that are being invoked, such as illegal, alien, and mental institutions. So this idea, where does this go back to? It goes back to the early 20th century with the eugenicists, and also the idea that strict immigration laws need to be enacted, that people need to be deported or stopped at the border. From 2 weeks ago, many of them murdered far more than one person, and now they're happily living in the United States. Now a murderer, I believe this, it's in their genes. And we got a lot of bad genes in our country right now. So this is another example of kind of Trump relying on this eugenic discourse to, basically make these stark categorizations of fitness and unfitness. And we know who he's talking about when he's talking about unfitness. And then finally, a very old trope in the playbook of kind of scapegoating of immigrants. People come in, they're very sick. They're coming into our country. They're very, very sick with highly contagious disease, and they're led into our country to infect our country. And actually, he said this in Aurora, Colorado, which is one of the places that he had, I think it was one of the places in addition to Springfield that he had identified as a site of, too many Haitian immigrants. So I just really want to underscore that these are demographic anxieties that were interwoven to the rise. They've been around for a long time, but if we look kind of with the election of Trump and the rise of the alt-right, and particularly, the kind of crescendo of kind of white nationalistic fervor, this is all part of the same package. And you can't understand the desire to control women's bodies or reproductive bodies, as well as controlling the bodies of trans and non-binary people. You have to connect it to this kind of xenophobia as well. It's part of a package, and we know what the package is, and it's a package that's defined by patriarchy and, neo or full fascism. And so anyway, I guess that's what we're dealing with. God, I'm always so depressing when I talk about things. I'm sorry. We do have a question on advocacy and activism, so maybe that will help get us in a better space. But I'm just so disturbed when I hear these quotes and the ways they're being bandied about. And they are off the cuff remarks, but they're not. See, any time someone is being sardonic, it's definitely a problem politically. And, Trump is a master of that, and he's a real kind of, freewheeling talker when he brings in that kind of sardonic point of view.
I'd love to hear your response to that. Sure. Yeah. Okay. That sounds great. Okay. So here again, in Mexico's 2 Supreme Court rulings, they, really embodied and took up and embraced a lot of what we've learned from reproductive justice activism in the last decades. Right. So on September 7th, 2023, this historic decision, Mexico's Supreme Court of Justice established that decriminalized abortion on the federal level, establishing that criminalization in the federal penal code is a violation of the human rights of women and transgender and non-binary people. And they very specifically included that language in the ruling so that it was clear legally in the Constitution that not only women were harmed by abortion criminalization and repression and lack of access, right? And so under this ruling, no one, including healthcare personnel, can be prosecuted for providing pregnancy termination services. And in addition, they instructed public clinics to always provide these pregnancy care and healthcare services when they were needed, right? Because with the last question, when women would show up at public clinics, then doctors and nurses and people there would report into the police, right? So what's important about this 2023 Supreme Court ruling is that they said, quote, the criminalization of abortion constitutes an act of violence and discrimination based on gender, as it perpetuates the stereotype that women and pregnant individuals can only exercise their sexuality for procreation, and reinforces the gender role that imposes motherhood as a compulsory destiny, right? So this is, dare I say, better than Roe? Not that we're talking, in terms of better and worse, right? But we always knew that Roe had some limitations and needed to be built upon instead of overturned, right? And so, this really, conceptualized a fundamental and inclusive concept that had the underlying purpose of recognizing and making visible those who belonging to diverse gender identities, different from the traditional concept of a woman, have the capacity to gestate. And, they also included language about, and I'll just, mention this briefly without reading through all of the language, human dignity, reproductive autonomy and free development of the personality, the secularity of the state, legal equality. So this right implies the elimination of gender stereotypes that are assigned to people based on the sexual organs they were born with, and reproductive health and freedom, saying that moreover, these rights must not only be recognized on paper, but the infrastructure must also be in place to allow for decision-making regarding one's own health. So that's, all from the 2023 Supreme Court decision. And, this has been used basically to challenge state level laws that still criminalize people's reproductive outcomes. And so just one example, and then I'll stop talking of how it was applied, was that in Coahuila, a local court concluded that when criminal law affects other rights, then it is not the proper way to protect the gestation process. And that from then on, any investigations against women or people with the capacity to gestate for the crime of abortion and against those who had assisted someone in having an abortion were to be closed. The same applied to anyone who had been sentenced or imprisoned for this crime, who from that moment on had the right to have the case reviewed in order to be released. Immediately the next day, approximately 7 people were released from jail where they were being held on suspicion of having terminated their own pregnancies. And so that just gives a taste of, what Mexican lawmakers have focused on.
Can I ask Cary a question riffing off of that, which is, what we see in that is a lot of reproductive justice because it's guided by human rights understandings of kind of international law, human dignity and equality. And in the United States, we're both empowered and kind of have our hands tied by civil rights and 14th Amendment interpretations. And I guess I'd love Cary to reflect on what can we do now, given, kind of the legal landscape and the options going forward, assuming the worst case scenario, but also assuming let's say a mid-range scenario, which still wouldn't be great.
So I don't want this panel to actually be all doom and gloom. Yeah. I'm a constitutional lawyer, and my work is actually developing the next generation of constitutional arguments to get us out of where we are with Dobbs. So I'm very forward-looking. The goal is to build up again and to create these protections, and I think we will. I don't know how long that will take. But we will. And I just want you to know, you should be proud if you are a California taxpayer. California, a couple of years ago, gave UCLA Law School $5 million to start up the Center on Reproductive Health Law and Policy, of which I'm the faculty director, with the idea that they saw Dobbs coming. They didn't even know it was going to be called yet, but they saw Dobbs coming down the pike, and they wanted to invest in research, a think tank that could come up up with the new constitutional arguments. And that is our center, and that is the work that we are doing. And I'm doing this with lawyers around the country. And to respond to this conversation, we're very interested in the Mexican and Colombian and other decisions that have framed, partly in terms of human rights, which is a much harder lift in American law. We don't generally incorporate human rights into our constitutional jurisprudence. But I mentioned the 14th Amendment protects liberty and equality. Roe was based on liberty. It was based on freedom. You could choose. You had autonomy to do what you want with your body. And that is what Dobbs killed. No, I don't think it entirely killed that, but it put a huge damper on that. It's very hard to bring a liberty claim right now because you have to prove that the liberty was deeply rooted in 1868. And that way I talked about that earlier, right? That's very hard to do for all of these things. Dobbs, however, made no holding about equality. It wasn't an equality case. That wasn't the argument in the case. The 14th Amendment also protects your right to equality. And we've had numerous other decisions around the world recently that have framed this in terms of equality. So part of my work over the last several years has been developing constitutional equality arguments that can be used in the reproductive justice context. And I spend an hour doing this in my Common Law 1 course, so I do not know if I'm going to be able to do it right now in 1 minute, but I am going to try to just tell you a little bit about what our equality doctrine is and the advantages and the challenges. Okay, so the way our equality doctrine works in the United States in constitutional law, if you are going to pass laws that discriminate against women or discriminate on the basis of sex, the government has to give its real reasons to the court, real reasons why it's doing this thing, has to state its governmental interests, and then it has to show that the means that it's using to achieve those interests are quite tightly tied to the interests that it's trying to achieve. They're not under-inclusive, they're not over-inclusive, they're not stereotyping or discriminating against women more than they need to achieve the objective or the interest that is valid. Okay, so here's the thing, and this is what I just published a chapter on this. In this context, the government says we have two constitutionally recognizable interests. One is we're passing abortion restrictions to protect women's health. There are rapacious abortion providers, and they are hurting women, and we need to protect their health. And also, we are protecting potential life or fetal life, but the health and well-being of fetuses we're trying to protect. Okay, the objective of protecting women's health is a lot easier, is very not hard if you're a lawyer to show that abortion bans harm women's health. To open the newspaper any day, you'll see big rises in maternal mortality, big rises in harm to people's health. When you close down all these health clinics, Planned Parenthood clinics, I came from Texas most recently, that's what provide all the cancer screenings in the Valley in Texas, right? Huge health deficits and problems when you close down all of these clinics. So that is not I think, consistent with a government interest in protecting women's health. What about fetal life? Right? That's the main argument in these cases. What's interesting about that is if you are a state trying to protect fetal health and well-being, what would you do? Right? You'd expand Medicaid because that is an enormous impact. You provide prenatal care. You provide vitamins. You provide housing support, drug intervention. You provide all the kinds of medical supports and social supports that are proven to improve pregnancy outcomes. So in some cases, like Medicaid expansion, fairly dramatically. We know that you would take all these steps. The states passing abortion bans are the states that have chosen not to expand Medicaid, that have the least social safety net, that have the most uninsured people, that have the worst rates of maternal mortality. The only thing that they are doing to protect potential life is persecuting doctors, shutting down clinics, and trying to stop abortion. That should be a problem under our equality law because the means are not closely enough tailored to the stated objective of the state. They're not acting like states that want to protect the health and well-being of their fetuses. They're acting like states that want to control women's reproductive lives, which is not a constitutionally acceptable aim. So there are good constitutional arguments that can be made in courts. We are making them in state courts. There was a very exciting recent Pennsylvania decision that followed along this way of thinking, and there have been other decisions of that ilk. This is not the only constitutional argument we are building, but it's one of them, and I think it's a promising one over time. Can I just end on a real downer? Okay. One of the reasons I love constitutional law, and it's so gripping and fascinating to me, it's never that easy. It's always complicated. It's always hard. It's always fun. It's always interesting. It's always important. Here's the challenge with this argument. 50 years ago, this is the thing that takes me 45 minutes to explain. 50 years ago, the court issued a decision in which it said discrimination against pregnant women isn't necessarily, or really has been read as, isn't sex discrimination. Discrimination against pregnant women isn't sex discrimination. If you fire someone because they're pregnant, that's not sex discrimination. Whew. Okay, and the reasoning is that only women become pregnant. That's why it's not sex discrimination. Wrap your head around that, right? The idea is you have to show that men and women are being treated differently or being treated unequally. If only women are getting pregnant, you're not treating pregnant men any worse or any differently, because in the court's view, there aren't any. You don't have that comparator group. Features, biological features that are the court views as distinct to one's sex, when you discriminate on those grounds, can't count as sex discrimination. No, this is a ridiculous, frankly, 50-year-old precedent that the court had never cited again after Congress rejected that view as applied to federal law. We have a weird situation in America where, as applied to federal laws, that's not the view. Pregnancy discrimination is sex discrimination under federal law, but under our constitutional law, it's not sex discrimination. It's very conceptually difficult to be glad you're not a Common Law 1 student. It's difficult to wrap your head around that. But after Congress made that move and said pregnancy discrimination is sex discrimination under federal law, the court never cited that decision again in a majority opinion until, guess when? Dobbs. In dicta, which means not the holding, but in chatter, rhetoric, Justice Alito just talking, he was like, by the way, you didn't make an equal protection argument, but I'm just going to reach out and say how bad I think that argument is because of this decision. It can't be an equality problem because it only affects one sex, and we know that can't. So he has expressed his view about whether that argument can go forward. That's not going to be the view of every state court. I don't think over time that may be the majority view, but there is a hurdle right now at the Supreme Court just to get positive and then let you know the challenges ahead.
You raised this issue of advocacy and activism. Let's talk about that to end our session. What can activism achieve where other efforts could fail? What would you like people to know about the future of these fights? Go for it, Alex.
Well, I can talk about the work this is an example of how researchers can help inform advocacy. So in our lab, we did a lot of research, showed, kind of the patterns of sterilization abuse in California. In 2017, we published a paper in the American Journal of Public Health, making a case for meritorious redress. In other words, there should be some sort of reparations or compensations for people who were harmed by the state through reproductive control. And that then kind of evolved into a working group coalition I was involved in for 4+ years with the Disability Rights Education and Defense Fund, California Latinas for Reproductive Justice, California Coalition for Women's Prisoners, and a few other groups. And I learned so much working with these groups about, first of all, how do they move ahead with kind of pursuing legislation? It took 4 tries to get the compensation bill passed. I think it finally happened the last year, which was 2021, that we tried it because we brought in the claimants from the California prisons who were more recent claimants. There are over about 200 of them who have been compensated, and they also were willing to tell their stories. So it's also the power of storytelling, and they talked about how they were harmed. I got to know many of them. A documentary was made, The Belly of the Beast. Some of you may have seen it, which talks about what happened in California women's prisons. So for me, you know, the optimistic story is that history can help inform advocacy efforts for justice. You need to work in patient collaboration with advocacy and activism groups and follow their lead because they know what they're doing. Often, me as a scholar, I was learning, you know, obviously I was learning from them, but we were providing some of the research that would really help inform the case. And in the end, we were the lab became the contact entity for the California Victims Compensation Board that would contact us and say, this has been submitted to us. Do you find this in your files, and so on and so forth. That's a more complicated story of how victims compensation boards actually work because they are an arm of the state. But nevertheless, for me, that would be an example of whatever would be the reproductive harm. How can you do the historical research, according to those standards of scholarly integrity, and then work with groups? You have to build alliances. You have to build trust. This is a slow-going process. I've put a lot of skin in the game to do this. You can't just do it overnight. But it's possible, and it can be very effective. And in fact, one of the people I worked with just got into UCLA law. She's doing the public interest law, and she's going to be working on these very issues with Latinas in California. So there's a great story of, her and, how this inspired her to move ahead with her career and do the very kind of, work that you're talking about. Okay, I hope I hit a kind of more upbeat note there. Yeah.
Well, that's all very inspiring. And, I co-sign all the, messages about building foundations and, making grassroots connections and working in coalition. And I just want to emphasize, I guess I don't have too much to say on this, but that in recent years there has been this massive feminist green wave because bright green is kind of, the symbolism that's used for these broad coalitions throughout Latin America in support of reproductive dignity to fight patriarchal controls in terms of forced sterilization or lack of access to healthcare or lack of access to pregnancy care, including pregnancy termination. So Mexico, Colombia, Argentina, and Uruguay have all made really significant strides towards decriminalization, legalization, and protection of access. And, in Mexico, first trimester abortion had been decriminalized in Mexico City since 2007, and then a couple of states followed suit, including Oaxaca, but then 16 states kind of, encoded in their constitution the right of the fetus to life since conception at the same time the struggle was happening. And so it was really slow, legally. But what I want to really emphasize was that there was a turning point, in around the pandemic, actually, that there was this massive march in March of 2021, in which hundreds of young feminists stormed the country's national palace in Mexico City, attacking the president's residence with bats, blowtorches, and hammers. And their demand, was an end to all gender-based violence. And so this was, building on decades and decades of protest against femicide and gender-based violence writ large. So the protest followed a massive demonstration that brought tens of thousands of women to the streets, many of them wearing these green handkerchiefs that were first seen in Argentina, and the Mexican women also did a national strike the following day. And so, when we look back on this, enormous grassroots mobilization of angry young people in the street, we see that just 6 months later was when the Supreme Court made their first ruling, right? So in September 2021, abortion was ruled on by the Supreme Court as no longer a federal crime. So while the criminal law is still there by state, they said that the 2021 ruling said that criminalizing abortion was unconstitutional. And what that did was set a precedent that led to the next ruling 2 years later of the decriminalization of all abortion. And so while the 2021 decision didn't automatically make it legal, it set this binding precedent. And so then what happened was that there was this grassroots strategy that relied not on lawsuits, even though I think, this can be a really valid strategy, but that was really moved forward by these NGOs that had been laying their ground for many, many decades, right? And so there was a National Center for Reproductive Rights that worked in coordination with many, many, many local organizations and healthcare providers. And essentially what they did was they found hundreds and thousands of women actually whose access to healthcare or reproductive rights, gender equality had been violated in some way. And then they brought this to small local courts and got decisions from local judges in these rulings known as amparos. And these were documents, containing a judge's decision to settle the dispute. And what happened was that, these amparos decisions built on each other in a way that really, validated this more national argument for Supreme Court. And the decisions often included language, reproductive justice language about human rights, including that, of a victim's right to comprehensive reparation, restitution, rehabilitation, compensation, satisfaction to restore, the victim's dignity and guarantees of not repetition by offending parties. And so you hear about, lots of kinds of offenses that people would complain about, for example, sequestration, and denial of access to health care that should have been protected. So,
yeah, I guess I'll say it has been a rough 2 years working on this every day. But if I step back for a minute, there is a lot of good out there, and this is some of it. But I just want to focus on the U.S. context where I'm more familiar. So I first of all think it is so important to continue to repeat what the polling and the data shows, which is Americans overwhelmingly support a right to abortion. And that is true even in red states, that most people support some right to abortion in those states. The position that has won the day at the Supreme Court right now is a very unpopular position. It is not one that Americans want, believe in. That's not how they understand the Constitution. That's not what they want our laws to look at. And you have seen that reflected not only in the big marches in Washington and in other cities, but in every time abortion has been on the ballot since Dobbs, the anti-abortion forces have lost. Every single time. It had a big effect. There's now data showing the 2022 midterms were influenced by, it's kind of like the dog that caught the car with anti-abortion forces. They got Dobbs, but does it necessarily help them? I don't know. They lost a lot of seats. There's going to be a lot of interest in the question, if Trump loses, how much abortion played into that loss, because this has so turned off, especially women voters, who may come out to the polls in numbers that we don't yet appreciate. There are ballot initiatives in 10 states right now. I think most of them, the anti-abortion forces will lose, that there'll be greater protections after this election on the state level. There are so many efforts going on in the states to get state legislation and to bring suits in state courts. It's unbelievable the amount of energy and effort that is yielding good results in the states that if you just pay attention to the Supreme Court, you will not see. There is enormous activism and protections that are important that are being won even in places you might not expect. I can't stress enough how much voting and democracy is tied with this, because there are a lot of the efforts to stop these initiatives and ballots have to do with suppressing the vote, have to do with getting things knocked off ballots, challenging procedures, challenging signature trying to stop democracy, because that's the only way to stop it. You don't have the votes to stop it because the people support greater protections. So anti-abortion forces are turning to a lot of anti-democracy measures to try to stop reproductive rights and justice initiatives from moving forward. So protecting reproductive rights and justice is a lot about protecting democracy. And I guess one thing I always tell my students who come to law school sort of bright-eyed, and then I inform them about the state of constitutional law in this country. But I'm sorry if this is earnest, but I believe it. Like, think of, it's 1868. The 14th Amendment has been passed. You have a liberty protection and you have equality protection. It's 100 years until Brown versus Board of Education. It's 100 years of Jim Crow and oppression and struggles that I would say were harder, and you're starting off in a worse place then than you are now. And people did not stop. They did not stop them. They fought, and we are doing that now, and we will do this, and this will come right. And it's just a matter of putting in the energy and putting in the effort. I don't know whether it will be sooner or later, but it will happen because this is something people support.
I want to thank these incredibly knowledgeable and articulate experts who have addressed so many compelling issues related to reproductive rights and justice this evening, who have exposed the casual, highly selective use and misuse of history by some people, mainly men in power, who are not trained in history, who do not study history, who misrepresent the past to suit their own unpopular designs and conceits. This deeply troubles us. It urges us to action, and that's why history matters. Thank you.